A fine morning to one and all. I myself, Dinesh, working as assistant professor in the department of MBA, DNR College. Dear students, today we are going to have a session on the topic duties of directors. Duties of directors from Corporate Legal Framework of third semester for MBA students. Dear students, so today let us see what are the duties of directors and what are the responsibilities, what are the qualifications and disqualifications of directors, and then what are the duties of directors. So overall today we are going to see in detail about the directors and the various things involved by directors. This is under Companies Act. Okay, Companies Act 2013. So let us see the definition. As per section 2 of 34 of Companies Act 2013, director means a person appointed to the board of a company. I repeat the definition. As per section 2 of 34 of Companies Act 2013, director means a person appointed to the board of a company. Yes. Next, Board of Directors. According to section 149 of Companies Act, the directors of a company are collectively referred to as the Board of Directors. Who are called Board of Directors? Board of Directors is an elected group of individuals that represent shareholders. Board of Directors is an elected group of individuals that represent shareholders. Generally, every public company must have a board of directors. Every public company must have a board of directors. So now let us see the responsibilities of board of directors. As every person in a company will be having some sort of responsibility for his duty. So what are the responsibilities of board of directors? The board of directors of a company is primarily responsible for determining the company's strategic objectives and policies. Determining company's strategic objectives and policies. So the primary responsibility of board of directors is to determine the company's strategic objectives and policies. The policies which helps to promote the progress of a particular company. The objectives for the well-being and well-promotion of a company. Monitoring progress towards achieving the objectives and policies. Soon after the determining continuous monitoring progress in achieving the objectives and policies. As the first part is determining and next continuous monitoring progress is the second ultimate responsibility of board of directors, and then appointing senior management. The most prominent roles, the most prominent profiles will be appointed by board of directors, accounting for the company's activities to relevant parties. Yes, example, shareholders. We all aware of shareholders. Shareholders are also known as stockholders, is an individual or institution that legally owns one or more shares of the share capital of a public or private corporation. Yes, generally most of the people may not correctly know the definition of shareholders, but there is a little idea that a person owns one or more shares of the share capital of public or private corporation can be easily termed as shareholders. And next one, let us see what are the qualifications of a director. As every job, every profile has been some qualifications needed and required. So what are the essential qualifications of a director? Before getting appointed for a particular post of director, what are the reasonable and minimum qualifications of a director? The rules governing the appointment are been allotted to a director identification number. It is a unique number, DIN, director identification number. Every director at the time of allotment has been allotted with director identification number. And the next one, signed the memorandum for his qualifications, shares from the company, and paid or agreed to pay for them. Signed the memorandum for his qualification shares from the company and paid or agreed to pay for them. What is memorandum? In general, we will know a written message in business can be termed as a memorandum. But coming to the law, a document recording the terms of a contract or other legal details can be termed as memorandum. Document recording the terms of a contract or other legal details can be termed as memorandum, which should be duly signed by a director. And the next one, signed and filed with the registrar a written undertaking, shares from the company, if any, and pay for them. Soon after the sign, and it should be filed with the register, a written undertaking, shares from the company, if any, and pay for them. These are all about the qualifications of a director. And now let us see what are the disqualification of a director. On what basis a director can be disqualified according to section 164. A person shall not be capable of being appointed director of a company if. So what are the if clauses that a person cannot be appointed as a director? First one, he has been found to be unsound mind by a court. Yes, if a person is of unsound mind, he is surely disqualified as a director. And also at the time of contracts we had already studied, a person of unsound mind is not allowed to enter into a contract. And the next one, he has applied to be adjudicated as an insolvent and his application is pending. Yes, he has applied to be adjudicated. What do you mean by adjudicated? Make a formal judgment on a disputed matter. Make a formal judgment on a disputed matter. Adjudicated as an insolvent. Insolvent, it's a term we had already discussed in previous sessions. Person is insolvent when the total liabilities exceed total assets. Yes, if his total liabilities exceeds his total assets, then the person can be regarded as insolvent and his application is pending. In simple, we can say the person who has applied to be adjudicated as insolvent and his application is pending is disqualified as a director. And the next one, he has been convicted by a court of any offense involving moral turpitude and sentenced in respect thereof to imprisonment for not less than 6 months and a period of 5 years has not elapsed from the date of expiry of the sentence. Yes, What do you mean by convicted by a court of any offense? Convicted, the act or process of finding a person guilty of a crime, especially in a court of law. Yes, if a person done anything wrong can be termed as crime in a court of law, then it can be termed as convicted by a court of any offense involving moral turpitude. What do you mean by moral turpitude? An act or behavior that gravely violates the sentiment of a community can be termed as moral turpitude. Violates the sentiment of a community. And here the new term is has not elapsed. Pass or go by can be termed as elapsed. Pass or go by can be termed as elapsed. If a person convicted by a court of any offense involving moral turpitude and sentenced in respect thereof to imprisonment for not less than 6 months, and a period of 5 years has not passed from the date of expiry of the sentence, he shall be disqualified as a director. So these are all the disqualification of a director. Until now, we had seen the qualifications of a director and disqualification of a director. And now we are going to see the appointment of directors. How a director can be appointed. Here we can see in the diagram appointment by directors by company, appointment of directors by central government, appointment by board of directors, appointment by proportional representation. Let us see one by one in detail. Appointment of directors by company. According to section 255, directors must be appointed by the company in general meeting. The appointment of directors by company in general meeting is a common practice for appointment of directors by company. Generally, at the first annual general meeting of a public company or private company, the appointment of directors by a company can be taken place. And here 1/3 of the directors liable to retire by rotation must retire from office. Where the appointment of directors by company, in that 1/3 of the directors liable to retire by rotation from the office. This is by the appointments of directors by company. And now let us see appointment of directors by board of directors. Yes, as additional directors according to section 260, the additional directors hold office only up to the date of next annual general meeting of the company, so that they can be termed as additional directors according to section 260. And then in a casual vacancy, that is under section 262, in a casual vacancy, director appointed by the company in general meeting may be vacated before his term of office expires in normal course. That is casual vacancy according to section 262. And the third one might be as alternate director according to section 313, as alternate director. In this, he is to act for a director called the original director during his absence for a period of at least 3 months from the date in which meetings of the board are ordinarily held. As alternate director, he is to act for a director called the original director during his absence for a period of at least 3 months from the date in which meetings of board are ordinarily held. So these are the 3 kinds of appointment of directors by board of directors. One is as additional directors according to section 260, in a casual vacancy according to section 262, as alternate director according to section 313. And then next category, appointment of directors by central government according to section 408. According to appointment of directors by central government according to section 408. The central government may appoint number of directors on the board of a company as company law board. In this we can see, to safeguard the interest of the company, its shareholders or the public interest. The period of appointment shall not exceed 3 years on any one occasion. So just to safeguard the interest of the company, its shareholders or the public interest, the appointment of directors can be done by central government according to section 408. The period of appointment shall not exceed 3 years on any one occasion. And finally, we are going to have appointment of directors by proportional representation. By proportional representation. In this, the articles of company may provide the appointment of not less than 2/3 of the total number of directors of a public or private company. 2/3 of the total number of directors of a public company or a private company. In this, cumulative voting is generally done. The appointment must be made once in 3 years, and internal casual vacancies must be filled in the manner as provided by the articles. Here we can see the appointment must be made once in 3 years. Generally, internal casual vacancies must be filled in this manner by proportional representation. So the appointment of directors can be seen in 4 categories. Appointment of directors by the company, where generally at the first general meeting of a public company or a private company it will be happened according to section 255. Nearly 1/3 of the directors are liable to retire by rotation. And then we had seen appointment of directors by board of directors, where we can see additional directors according to section 260, casual vacancy according to section 262, alternate director according to section 313. And then we had seen appointment of directors by central government according to section 408, just to safeguard the interests of the company, public and shareholders. The period is not exceeding 3 years. And then finally we had seen appointment by proportional representation, where 2/3 of total number of directors of a public or private company, and then the appointment will be made once in 3 years. Generally, internal casual vacancies must be filled in this manner. And then next one, let us see resignation by a director. How a director should be follow the process of resignation. A director may resign from his office by giving a notice in writing to the company, and the board shall take note of the same. The company shall intimate the registrar and shall also place the fact of registration in the report of directors laid in the immediately following the general meeting by the company. A director may resign from office at any time, but he should give a notice in writing to the company, and the board shall take note of the same. The company shall intimate soon after providing the resignation. The company shall intimate the registrar and shall also place the fact of registration in the report of the directors immediately following general meeting by the company. And next, a director shall also forward a copy of resignation to the registrar along with detailed reason within 30 days of resignation. Yes, a detailed reason should be mentioned by the director for the process of resignation. The copy should be forwarded to the registrar. The resignation shall take effect from the date on which the notice is received by the company or the date specified by the director in the notice, whichever is later. So generally, the resignation will be kept effect from the date on which the notice is received by the company or the date specified by the director in the notice. And then the directors who has resigned shall be liable even after his resignation for the offences which occurred during his tenure. Though the director has resigned from his post, he or she shall be liable even after resignation for the offences which occurred during his tenure. And then let us see the duties of directors, which is the prominent and important thing. Duties of directors can be categorized into statutory duties and general duties. So first, let us see the statutory duties. Yes, first one, inspecting the prospectus. It is the prominent and important duty of a director to inspect the prospectus. Generally, we all know what is the meaning of prospectus. The formal document required by and filed with Securities and Exchange Commission (SEC) that provides details about an investment offering to the public. And then signing the prospectus. Later on, presenting annual statement. Generally, annual statement is the report provides an overview of a company's financial information for the previous year. Financial information of a company for the previous year can be termed as annual statement. And then holding the statutory meeting and forwarding the report. What do you mean by statutory meeting? First meeting of shareholders of a public company can be termed as statutory meeting. And then convening the general meeting. Meeting of company shareholders, unlike a board meeting, can be regarded as general meeting. And then convening the extraordinary general meeting. Declaring and paying dividend. Yes, we all know what do you mean by dividend. Distribution of profits by corporation to its shareholders can be termed as dividends. And then presenting annual accounts. The company accounts presentation can be also termed as annual accounts. And finally, sending copies to registrar. All the information related copies should be sent to register from time to time. These are all the statutory duties that should be performed by a director in a company. And then let us see what are the general duties. What are the general duties of a director? Here we can see act within powers. Act within powers. A director must act in accordance with the company's constitution and only exercise his powers for the purposes for which they are given, so that he should not be using misuse of power. He should act according to the company's constitution, exercise his purpose for which they were given. And the next one, promote the success of the company. The director must act in good faith, most likely to promote the success of the company for the benefits of its members. He should always strive hard to promote the success of the company for the benefits of the members as a whole. And then exercise independent judgment. A director must exercise independent judgment and make his own decisions. That should not exceed in accordance with company's constitution. And next one, exercise reasonable care, skill and diligence. Exercise reasonable care, skill and diligence. What do you mean by diligence? Careful and persistent work or effort can be termed as diligence. Careful and persistent work or effort can be termed as diligence. Yes, as a director, the director should exercise the same care, skill and diligence that would exercised by a reasonably diligent person with a minimum general knowledge, skill and experience that should be possessed by a director. And the next one, avoid conflicts of interest. Avoid conflicts of interest generally at a conflict situation. The director should have the capacity to avoid a situation where the conflicts might arise in a company. Always he should take care that the conflict should be minimized and promoting harmony in the organization. And then not accept benefits from third parties. Not accept benefits from third parties. As a director, he or she must not accept a benefit from a third party because he or she is a director and he should act according to the reasonable manner. If he accepts anything from the third parties, and it would be leading to the conflicts of interests. So these are all the general duties of the directors. Dear students, until now we had seen who is a director. As per section 2 of 34 of Companies Act 2013, director means a person appointed to the board of a company. And then we had seen responsibilities of board of directors. Yes, determining the company's objectives, monitoring progress towards the achievement of objectives and policies, as well appointing senior management. And then we had seen qualifications of a director. The person of a director can be allotted with director identification number DIN, and then he should duly sign the memorandum and then signed and filled with the registrar and undertaking shares from the company, if any, and pay for them. And then we had seen disqualification of a director according to section 164. Yes, a person of sound mind is disqualified as a director if he is insolvent and his application is being pending, and then if a person is convicted by a court of any offense involving moral turpitude, is not eligible as a director. And then we had seen appointment of directors by company according to section 255, and then appointment of directors by board of directors of three types: as additional directors according to section 260, in a casual vacancy according to section 262, as alternate director according to section 313. And then we had seen appointment of directors by central government according to section 408 just to safeguard the interests of public and shareholders and company. And then appointment by proportional representation. Internal casual vacancies will be filled in this manner, and generally appointment must be made once in 3 years. And then we had seen resignation by a director. A director may resign from his office by giving a notice to the company, and then the director shall also forward a company of his resignation to the registrar with the detailed reason, and also the resignation shall take an effect from the date on which the notice is received by the company or the date specified by the director in the notice. And also the directors who has resigned shall be liable even after resignation for the offences which occurred during his or her tenure. And then we had finally seen the duties of directors. Statutory duties: inspecting prospectus, presenting annual statements, convening general meetings, holding statutory meetings, presenting annual records, annual accounts, sending copies to registrar. And then we had also seen general duties of directors: act within powers, promote success of company, exercise independent judgment, exercise reasonable care, skill and diligence, try to avoid conflicts and to promote harmony, and not to accept any benefits from the third parties. So these are all about the directors which are mentioned in the Companies Act 2013. Hope you understood the lesson. Stay tuned for more updates. Thank you.